Good afternoon, Mr. Nkosi.
Good afternoon, Chief Justice. Good afternoon, Commissioner.
How are you, sir?
I'm very well, thank you, Chief Justice, and trust you well too.
Yeah, I noticed that just like me, you started at Zululand and then went for LLB at the University of Natal.
Yes, that's where we originate from, and we're proud of it.
Yes. Tell me very briefly about the purpose of, or the role of paralegals, very briefly.
Well, we provided them with basic training to assist their communities in rural areas of KZN in matters which, were prevalent at that time. They were administrative in nature, basically. So, I mean, issues that rated top of the list would be pensions. They would not be getting their pensions. And sometime we found that they've just been stopped without a reason. Or in other instances, people have applied, nothing has come through, and they just sit there. So the role of paralegals was to come and close that gap and ensure that there is accountability from the administrative side as to what's happening. And actually it instilled the interest in administrative law. Hence, when I served my articles, I ended up serving in a firm which had an administrative law department. And I've been doing that ever since.
Yes. Do you have some advice centers? Did they, not you necessarily, did the paralegals set up some advice centers in the townships, or are you not aware whether it went up to that level?
Well, at the time they had offices in the rural areas because there were other centers in urban areas. So we concentrated exclusively in rural areas, which meant a lot of traveling for us. And we were youngsters from university, so traveling to rural areas, we had to acclimatize to that. So it was a very challenging time, but it was worth it because the money we recovered for those people, it was phenomenal.
Wow. And you've been an attorney for over 17 years, am I right?
I beg your pardon, Chief Justice?
You've been an attorney for more than 17 years, am I right?
27, actually.
27? Why do I always get calculations wrong?
I served articles in 2002.
Yes.
And yes, and then thereafter I went back because when I left the community law center where we were training paralegals, I said, yes, I'm originally from here, from Gauteng. So I said, I want to go back to Gauteng to serve articles. They said, what if we find your articles here in KZN? I said,
when were you admitted?
In 1994.
Okay, all right. And you've acted as a judge as well?
Yes, I have. Since from
how many weeks, how many months? Or how many months?
Actually, I've done 9 stints now because I did my last stint recently. I was at the Durban High Court from the 18th of January, and I finished on the 26th of March. So all in all, I did 9 stints, which is 4 months each. So it translates to about 36 weeks.
And for how long what is the longest you've kept the judgment reserved for?
Well, I have a very big practice. So once I go back to my practice, it's very difficult to write judgments. So what I've tried to do is that before I finish my stint, I've finished all my judgments. So I think if I'm not wrong, I haven't kept the judgment for more than 6 weeks. Every time, by the time I finish my acting stint, all my judgments were done.
Thank you. Colleagues, let me have the names of those who have questions for Mr. Nkosi.
Sigogo. Singh.
Shmema.
JP.
Muhimang, Chief Justice. Thank you, Chief Justice. When was your first stint acting as a judge?
It was in 2011.
And that was in Durban?
It was actually in Pietermaritzburg.
And who was the JP then?
It was Judge Patel, Chiman
Yes.
Patel.
Yes.
And I remember you were senior civil judge at the time, and the very first day I was given motion court.
Did I do that to you?
Yes, and in fact, I had a list of questions that I wanted to pose to the senior civil judge before I went to the motion court. And I got there at 7, hoping that I'll be getting the assistance, but I waited and judges started arriving at 8. And I thought by that time there were lawyers waiting outside to introduce themselves. But I did well and I finished the motion court within a reasonable time, which was not bad.
And my recollection of you as you did both crime and civil, and that has always been the case when you came and acted.
Yes, in each time when I did two stints, I will do the first one civil, do the next one crime.
Yes. Any challenges you found while acting?
Well, there were challenges in the sense that sometimes, I mean, there are instances where you don't get the administrative support that you expect. I mean, the files will be brought to you late. The record is too thick, then you have to try and go through it within the time, you know, which is available to you. And other than that, you know, there were things that I was like acclimatized to, or I was used to, because I've always worked in a very busy practice. I mean, it's not unusual in my firm to find people working until 9 in the evening. So if it means working long hours, I could do that. Yes.
I see your practice largely involve local government and administrative law.
That's correct.
Yes. There's quite a bit of this sort of work coming up in KwaZulu-Natal.
Yes.
Have you done any of that work while on the bench?
While on the bench?
Yes.
Well, I've had cases which relate to those fields while I was on the bench, and I must say it actually equipped me with the skills to deal with it, because it's a specialized field. Even lawyers who show up in court sometimes are not very familiar with the legislation, because there's a plethora of legislation that they have to go through. So what I would do is to guide them through it because of my experience. And it's come in very handy with me acting as a judge, because it's a skill that's not usual. I mean, in the whole country, I think there are a handful of people who specialize in both administrative law and local government.
I also see from your practice that you didn't really litigate on your own.
I actually litigate through, because my clients are parastatals, corporate bodies, and other institutions which actually insist that they should be counsel. And I think there's good reason for that, because as an attorney, I think I did explain this at my previous interview, that once you're seized with a matter as an attorney, you tend to actually focus on it subjectively through your client's point of view. You need somebody who is going to serve who's actually going to give you another perspective of things that you may be overlooking in the process. So having counsel helps in that, because I know my cases very well. I'll sit down with counsel and say, this is what we need to do. This is the legislation. These are the facts. This is how I think we need to go about doing it. Counsel will give me feedback that, okay, I think you actually are overlooking this, this, and that. So that two-way process helps, as opposed to having me as an attorney going out to argue the case myself, only to find that there are issues that I've overlooked and they are brought to my attention in court, and I never thought about them. But if my clients say we can afford it, get counsel, and I insist on doing it myself, it actually tends to be counterproductive.
Now, the fact that you haven't actually litigated on your own, so to speak, do you find that a disadvantage sitting on the bench as a judge?
JP, when you're saying litigating on my own, you mean like go and argue the case myself?
Yes.
Actually, there are cases I don't think it actually affects me in any way, because an attorney's practice is very busy and hectic. Advocates on the other, I'll have about, in my diary every morning, about 20 files that I have to go through before I go home. So if I have to sit down, draft particulars, prepare the pleadings and send them to court, go and argue the case, it tends to be counterproductive to my time as well. Yet if I actually formulate the issues the way I think they should, then thereafter I go to counsel, we sit down and say, this is what I've done. You run with it, and then we'll discuss it once you've actually got your teeth into it. it helps because the client gets the advantage of 4 sets of eyes looking at it as opposed to just 2.
Yes. Thank you, Chief Justice.
Thank you, Judge President. Honorable MEC.
Thanks, Jay, and good afternoon, Mr. Nkosi.
Good afternoon.
Do you think it's possible or even desirable that at some stage we can have paralegal work extended and tailor-made for judges as part of extending access to the judicial system?
Well, I don't see any reason why not, because as long as there are people who will be there to guide paralegals, because it's very important that you provide guidance to them so that whatever they do, they don't end up doing something wrong, which should then backfire, and then they find themselves being sued. So if you are going to put mechanisms in place which would serve as guidance for them, then by all means, I would say, let's incorporate them into the whole system so that it could just, as cascade upwards towards the courts. The mistake that we tend to do is that we tend to say, we want to extend justice. Well, let's bring more people in, and then we bring people in, but we don't equip them with skills to deal with issues that are going to arise. Then when things go wrong, litigation is very dicey because you can be sued for damages. Then they end up facing actions for damages, and there's nobody who's going to cover them because the chances are they won't be insured. So we need to be circumspect, but I think it's a good idea.
No, thanks, CJ.
Could I follow up on that, CJ? Very short one.
Yes, sir.
Thank
Yes,
you.
sir.
Good afternoon, Mr. Nkosi.
Good afternoon, Mr. Matonsa.
I know I don't look like him, but anyway.
Oh, I'm
No,
making,
that's Judge President.
my apologies, Commissioner. I thought it's coming from Mr. Matonsa.
The JP is taking compliments. But they do look alike.
My apologies, JP. I was looking the wrong direction.
Thank you. Mr. Nkosi, your work with paralegals is impressive because it's one of the bases that buttress access to justice. You know that. I suppose that's why you do it.
Yes.
Now, my question is, your expertise in doing that, if we recommend you for appointment, would you be in a position to assist the JP? And I'm saying this because I didn't hear you mention it, in establishing pro bono help desks that are manned by paralegals in the high courts, because it's a model that works elsewhere. Because the problem is high courts daily have unrepresented people who come, and when you want to respect the equality of arms principle, you've got to assist them one way or the other. And that model has proved to work.
I'll be more than happy to assist in that regard if I am asked to, and in the event of me being appointed, JP. Thanks.
Thank you, Mr. Nkosi. Thank you, CJ.
Make a quick follow-up, CJ. Sir Clara.
Yes, Honorable Father.
Thank you very much, CJ, and good afternoon, Mr. Nkosi. I need to call you by your first name.
Yes,
just as a follow-up to the questions that have been raised on paralegal training. Back then, I'm not too sure if it is still happening now. Universities used to conduct community law clinics. And you have been involved in paralegal activities. If you are successful, would you support government, or rather, let me say, traditional authorities who are now, in terms of the law that will soon be passed and signed into law by the president, the traditional courts bill? Would you assist the province with the capacitation of those who would be designated to dispense justices in inverted commas, as it is envisaged by this bill that will soon be passed and signed into law by government, is an area that many people, especially in rural areas, saying has not received sufficient attention, and that needs to be, attended to. Would you be of assistance if you are successful in this position in that respect? Thank you so much.
Yes, I will be. And the advantage is that I've done it before and we did it very successfully. We covered the lengths and breadth of KZN in areas where I never thought I would be. And we would get there first, get to know the culture of the people and get to know the people well, get introduced to the Nkosi. Once you've actually done that, it helps because then the people buy into it. Then you build structures which are going to be of assistance to everyone. So I think it's a very good idea if it can be taken forward.
Thank you so much, CJ.
Thank you, sir. Commissioner Sigobo.
Thank you. Thank you, CJ. How are you, Mr. Nkosi?
I'm very well, thanks. And how are you, Mrs.?
I'm good. And how is Mr. Son?
He's very well too, and I'm sure he sends his regards.
Okay, thank you. My question is on paralegal today. The follow-ups nearly touched what I wanted to ask you on. You for sure value the work of paralegals. The Legal Practice Council, in terms of the Legal Practice Act, is required to advise the Minister of Justice, who is fortunately with us here today, on the regulation of paralegals, whether they should be regulated with other legal practitioners or separately. What do you think? And yeah, let me leave it there. What do you think?
Yeah, I think regulating them without putting the framework first may be a bit problematic. So what I think we need to do is first, let's put them in a position where they can deal with the matters which are presented to them. And then once we have done that, then we can start regulating because they will know what their responsibilities are and how far they can go so that they don't end up trampling on the toes of attorneys who would say you're taking our work, or advocates saying you are now impinging on what you shouldn't be doing. So we need to actually try and balance the scales in such a way that they are going to know this is how far their lane extends. And from there, if issues are beyond their comprehension, they need to be dealt with by attorneys. But I think it's doable. It's a process that is actually capable of being done.
Thank you very much. Thank you, CJ.
CJ, a follow-up.
Thank you, sir. Please go ahead, Commissioner Matolo Dlepu.
Thank you, CJ. Thank you, Mr. Nkosi. You know, the paralegals for me, it's one of those that community that we need in South Africa, and we need to do it in such a way that they feel respected. And as Mr. Gogo said, we as the Legal Practice Council, we had to advise the ministers, but when we engaged with them, some of them felt that their only issue is funding. And funding, the government is not doing anything about their funding. And so I'm just trying to tap on your knowledge that what do you think is the best way for us to go so that the organized profession doesn't feel they're competing with them? If they are necessary, we need to do something. I mean, they are providing access to justice, but what do you think can be done?
I think we actually need, the starting point is first to ensure that we get them to understand their terrain, that this is what you're expected to do, because the importance of them is that they are like the rubber on the road. They are the ones who are in direct touch with communities. But if they can do that without support, then it's not going to be of help to anyone. So if the government can set aside a portion, I mean, it can make an allocation that let's try it out on a pilot project basis. I think it's something that can, once it's off the ground and we can see that it works, then we can even get the private sector chipping in to actually add to the cost that is required to make it a success. But the starting point is first, let's sit down, put the framework on the table, get the organized legal profession to buy into it, so that we're not going to get people saying you're taking away our work. We now, because people are coming to you for free, because paralegals will be charging close to nothing, if anything at all. So we need to make the organized profession, legal profession, that these are people who are actually going to complement the system that is available, not take away anything from you.
Just for further follow-up, the organized profession has come to terms that we are understanding that we need paralegals. They have to be there. They're not taking their work, and they are very, I mean, they're actually, we know our roles both. But the only issue that I had, because I thought maybe if we say the legal profession can actually assist the paralegals, like community-based organizations, as a pro bono service to them. Maybe a firm of attorneys goes there once a week to facilitate whatever matters. I had that in mind, but I just wanted to know what you think about that.
Yeah, in fact, when I was, sorry to cut you short, Commissioner. When I was at the Community Law Center, what we will do is that they will take cases as and when people were coming in. And then because they are far from us, we would have weekly or bi-weekly visits. So they would have cases that they are going to deal with. They'll tell us, we've dealt with these, they're straightforward. We tried dealing with these, they are too complex. And then we will sit down with them and say, let's see where you fell short or where you went wrong. They'll say, well, I couldn't understand this, or I went wrong here, or people came back with me. So we gave them the guidance on an ongoing basis, so that they didn't feel like we just dropped them in the lurch for them to try and swim on their own without assistance. So if the legal profession buys into it, I think it's a very good idea that you're suggesting that attorneys commit that we will be there on an ongoing basis to help. If you need a problem, pick up the phone, or let's arrange a day when I'll come to you, list all the problems, and we go through it. And in the process, I educate you how to deal with the same problems if they do arise in the future.
Thank you, CJ, and thank you, Mr. Nkosi.
Thank you very much, Commissioner. And just by the way, Mr. Nkosi, what I've picked up is that those that have been properly trained help to ease up the role of both the magistrates' courts and the high courts, because they solve most of the problems before they get to court, and they direct people correctly to where to go when their cases have got prospects of success. And those that have partnered with the magistrates, like the magistrates' courts in Garankuwa, for instance, have helped the justice system enormously in reducing the caseload and ensuring that people get proper guidance before they waste their money in litigation.
Indeed, CJ. In fact, it's streamlining the process, making sure that it cascades to the correct level, because it's pointless someone going to an attorney with a claim that's, with something that the paralegal will resolve in a few hours. Yeah. Then the attorney is going to charge fees and stuff like that. So we need to avoid that if we can, as much as possible.
Yeah. Honorable Singh.
Thank you very much, Chief Justice, and good afternoon, Mr. Nkosi.
Good afternoon, Commissioner Singh.
Yeah, I'm very pleased that you are offering yourself to the bench with all this wonderful experience that you've got. But what I'm trying to understand is that you are not only a partner, but a director of one of the larger firms in Durban, very, very successful firms. And you said it's a very, very busy practice. You've offered yourself intermittently from 2011 to now in acting positions. I just want to know what motivates you to now join the bench? What is that motivating factor that wants you to join the bench and leave a thriving practice? Thank you.
I've done what I'm doing for 27 years, as I said. It actually it ends up breeding complacency, that it comes too easy, and I think it gets to a point where you think your mind is not stimulated enough to expand. So as I get called to act, and I'm very grateful to my partners because they've never raised an issue, although I have a budget to write like everyone. So for that, I mean, a credit goes to them. But the thing is, they've allowed me to do that as part of first making sure that our practice also contributes to the legal profession in our province. And at the same time, for me as an individual, it makes me grow, because every time I've acted, I've acquired experience which is invaluable. And when I go back to my firm, I go back as a better lawyer than I was when I came in. So if I end up joining the bench, I know it will be the blessing of my partners, and I will make a difference. And they would also say, that's one of our own and is making a contribution to the legal profession in our province.
Yes, one of your partners was a commissioner as well on the JSC of your company.
Incidentally, I was his tutor at varsity. So he and I have gone the same paths, because he was a very diligent student. The others, I would have to chase them to tutor them. In his case, he'll be working outside my dorm room every evening, and to the extent that I was the one who had to run away for him at times.
Yes, it was Commissioner Msomi.
Yes, that's it.
Yes, CJ. My second question relates to an answer you provided under legal background, where you appeared for Abahlali Basemjondolo. And you say you criticized the majority judgment of the Constitutional Court in that matter. I'm just trying to understand, I couldn't grasp from what you wrote there, what was the nature of the challenge and why you criticized that.
Okay, let me try and explain the issue quickly. What the province came to me, to us at the firm, and said, we need to eliminate slums in the province. We need to come up with legislation which will enable us to do that. But we don't want to render people homeless in doing that. So how do we go about it? So we sat down with the province and said, okay, let's work through what the provisions of the legislation are going to be. First, you can't render people homeless because the Constitution says you must move them from a place and put them in another place. So the province said, it's fine, we'll have transit camps where if people are moved and housing is not ready, we'll put them there. So we said, that's fine. And if you move them, it has to be in terms of pie. There's a legislation that actually regulates how you go about doing it. That's fine. So we did that. And then we had road shows where we explained that to all the people who are going to be affected, including people who live in these areas. Once we did that, and then we drafted the legislation, went out and said and explained it to the people what the provisions are. Then Abahlali took the legislation they wanted to challenge the constitutionality of the legislation on the basis that it's going to render them homeless. And we explained to them, I mean, a countless number of occasions, that no, what the province wants to do is to actually either upgrade the slums or the informal settlements in situ, which means where they are. If they are not capable of being upgraded, move people to places which are actually habitable, fit for human habitation. And nobody's going to be rendered homeless in the process. They were not satisfied with that, so they took the case to the KZN High Court. And the KZN High Court, the judge president at the time, was hearing the case, and he found nothing wrong with the legislation. So they took the case to the Constitutional Court. And at the Constitutional Court, they said, no, the old legislation is unconstitutional, and the reason is going to render us homeless. And we filed papers saying it's not going to render anybody homeless. This is why. Before a person can be moved, there has to be an alternative place. And if you move them, you can't just do it nilly-nilly. It's got to be in terms of pie. When the case went to the Constitutional Court was actually presented with a case where the whole constitutionality of the legislation was challenged. A day or so before the hearing, they then limited the challenge to 5 sections. They said, no, we are satisfied with the other sections, but there's a problem with just 5. We went to the Constitutional Court, and outside the steps of the court, they said, no, we want to effect further amendments. There are only 3 sections that we want to challenge. and they challenged those sections, and we still had an answer to each challenge that they raised. The finding of the Constitutional Court was that Section 16 of that legislation is not constitutional. And the reason, because it says you can move people without complying with PI. It didn't say that. It said you can move people, but when you do that, do it in terms of PI. So my challenge was, how could you move them, or how could you order that they be moved if it's going to be not in compliance of PI when the legislation explicitly says do it in terms of PI? So I have the article here. That's all that it said. The one judge who dissented was Judge Yakub at the time. And he gave the reasoning the very same way that we've explained to the people. And in effect, I was agreeing with the minority judgment. But I know that maybe the language I used was too robust in the sense that I was seen to be attacking the Constitutional Court. I wasn't.
Yeah, I did read that article some time ago, and it's good that you are appearing here now and that you've explained yourself. Thank you, Chief Justice. Thank you, Mr. Nkosi.
Thank you so much, sir. Prof.
Thank you, CJ. Mr. Nkosi, could you tell us what your judicial philosophy would be?
Judicial philosophy, I always explain it this way, that the judiciary is like oil. The constitution is like various corks, and you need to have the oil to make all the corks to run smoothly against each other in a way that's going to be harmonious in society. So my reasoning in terms of the judicial philosophy is that it should operate in such a way that there is limited conflict in the society in a manner that is going to be just. It differs in the constitution in the sense that we all have constitutional rights, but in the process of exercising those rights, they may clash, they may conflict, and things may arise. That's where the judiciary must come in and say, okay, this is how the thing must be regulated in a manner that is going to still be in compliance with the Constitution.
Thank you, sir. And your understanding of the rule of law?
The rule of law is that, well, my understanding is that whatever, well, the courts do should actually either not clash with the Constitution to start with. So it should be in line with the Constitution. And it should also take into account the rights of individuals in being exercised. And that there's also room for Ubuntu to be brought into it to ensure that the whole thing is completed.
Thank you, sir. Thank you, CJ.
Thank you, Professor. Honorable Member.
Thank you, Chief Justice. Good afternoon, Mr. Nkosi.
Afternoon, Commissioner. I'm really looking in the right direction this time.
Great. I see that in your questionnaire, training that you provided is mainly centered around the work that you did with SALGA and municipalities. Yeah. And I want to pose a question around the basis upon which a court will set aside a decision of a meeting of council that is not convened in terms of the standing rules of order. What grounds will you set aside such a decision of a council that is not convened in terms of the standing rules of order? Because a municipal council is a creature of statute. The second point, just to elaborate on that, do you think it is correct sometimes for the court to go to the length of setting aside decision of a political party? The basis for these two questions is informed by the opposition party in Cape Town and in Kimberley. In Kimberley, the opposition party convened a council meeting that was not, that did not correct and remove the mayor. So what will be the basis for you to reinstate that mayor? In Cape Town, I think one of the commissioners here, led the matter of delete. It looks like the party, I mean, the body that terminated her membership was not properly constituted. And the attempt by the opposition party to remove the mayor using that termination of membership was set aside by the court. What will be the basis upon which the court will strike those decisions down? Thank you.
Okay, let's start with the rules of
justice.
Yeah, thank you, Commissioner. Let's start with the rules of order. The rules of order, like the guideline or the constitution of the council, they are saying we're going to be operating and we're going to follow a certain procedure when we operate, and this is our procedure. And if they deviate from that and they do something that's outside of those rules, then any one of them should actually come up and say, we've deviated from what we agreed. And if that is the case, why should it stand if one of them is going to challenge it? The problem is that as the court, you won't read in the paper that they did this and then do it meremoto on your own. But if one of them stands up to say, it did not happen the way that we said it should, because the reason why you have rules of order is because you need to regulate the process in a way that's going to be acceptable to everyone. So if it's challenged on review by any one of them, it will be set aside on that basis. I'm not sure if I answered that one correctly. Okay, the second one, not even in councils, if you have a quorum, in any constitution that our quorum is this, and you hold a meeting, you find that you don't have a quorum. Why are you going ahead to hold that meeting? Or why are you going ahead and making decisions? Because that means the number of bodies who are wanted to make that decision are not there. So if you make that decision, the decision is going to be invalid. But there too, I can't read in the newspapers, the court, and say they did this, so I'm going to set it aside. One of them should challenge it on review to say, this is how it happened, and I want to set it aside. So the court can come to the assistance.
Thank you, Mr. Nkosi. Thank you, Chief Justice.
Thank you, Honorable Muimang. You are excused, Mr. Nkosi.
Thank you very much, Chief Justice. Thanks, Commissioners.
Thank you, sir.